Yeah, as Gwendolyn says, he didn't go beyond the statute of limitations. Exactly. He had years to file this. Years. I believe in Florida, for defamation, you need to file it within 2 years. And he just waited a few months. So that is a stupid argument. I think that is also an argument of law. And I'm not entirely sure why they didn't object to this, because the jury is not the interpreter of law. They are interpreters of facts. The judge is the interpreter of law. And now we have another sidebar. 2.5 days in. Sidebar counter 20! Oh, there's a lot of sidebars here. Skipping. Oh, it's a long one.
That's right.
Yeah, thank you, Your Honor. Mr. Young, I want to focus on your alleged economic damages. Okay, so I'm trying to understand your argument about economic damages. So I think you testified yesterday. Tell me if I got it wrong. That since the CNN broadcast, you've had no work. Is that right?
Correct.
And would it be your contention that since the CNN broadcast, no one will deal with you?
Yes.
Fair to say that your testimony is that you're a pariah?
Yes.
And you allege that that's because of CNN?
Yes.
And so just to make sure I understand it clearly, your assertion is that since the CNN publications on November 11th, no one will work with you?
That's correct.
Sir, is it true that in December of 2021, you signed a consulting agreement with a government contractor called Helios Global?
Yes.
And what I'd like to do, I'm handing you what's been marked as Defense Exhibit 589. Is there a message you show us?
It seems like most of the defense here is against the damages, not against the actual defamation. And with $1 billion defamation claim against you, yeah, that's a good focus. But if you can show that you didn't defame him with more than the garbage you put forward so far, this could go anyway. With the, well, in my opinion, because this is not beyond reasonable doubt. Remember that, folks. Mr. Zachary was not a public person, so it doesn't have this even at the heightened the level of evidence or whatever's. So this is, to my knowledge, it is more likely than not that they defamed him, which is the 50-50 plus a feather. And I do believe so far CNN is doing a poor job of that. So yeah, but that's the facts that they have to work with. So yeah, I would assume that damages, that's the thing they have to work with. And I do believe that $1 billion is a very, very high ask, because that insinuates that he would make or lost $1 billion, somewhere in the region of $250 million, and then with general damages 3 times that amount, with a combined $1 billion. So a $250 million. His highest taxable income year was, I believe, $550,000. So yeah, we'll see.
Yeah, you're on that, Roger?
Hey, Q.
May we approach for a minute?
Your Honor, pending questions. I would like
Auto Doctor, how many years of lost income are they figuring for? Well, they are going for, he is completely banned, blacklisted from the area he worked in. Completely banned. Because his face is out there, his name is out there, and it's connected to human trafficking. So they are probably going for the rest of his life, or rest of his, as an adult, the projected number of years he was supposed to work within this field. That is what I assume. So that could be, I don't know, I believe Mr. Young is in his 40s, so say 20 years, another 20 years, plus emotional damage and other things. But 20 years, and if they count by that his highest taxable income, so that is 550 times 20, 10, is it? 10 million bucks?
to ask them. I don't think there's a question that's pending. I don't think that there's a reason for an objection. I'll ask a question.
Stock was on the exhibit.
It's for impeachment.
What do you mean for impeachment? There's nothing to impeach.
And they are doing that in front of the jury. I don't like that. But it's another sidebar. Sidebar counter 21. Oh, there's a lot of sidebars here. Skipping. Jesus Christ, that was a long one. Okay.
All right, ladies and gentlemen of the jury, I apologize. It's a little early for an afternoon break, but there's a matter I need to talk with the attorneys a little bit more extensively than just doing it in sidebar. So what we're going to do is we're going to take a break for the next 20 minutes. Obviously, y'all can go out, the restroom, if you need to use your phone or what have you. I just ask that you be back in the jury lounge room outside there to gather back up at 10 minutes to 2. So that's 20 minutes from now. All right. Hopefully we can get this resolved before then. If we're still talking, it may take a little bit longer, but if you could be back there at 10 minutes to 2, we'll try to get you back in here. Go ahead and take your notepads, put them in the folders that are there, leave them on your chairs, and I'll read the instruction to you again. We're going to take a recess. Remember, all the rules I've given you apply even when we're outside the courtroom, such as that recess.
Please say that they are doing
Remember the
this
basic rule, do not talk to anyone, including your fellow
cameras.
jurors, friends, family, or
I want to
coworkers
know.
about anything having to do with this trial, except to speak to
I want to know.
I guess to frame the issue that we have at the moment is we have a just discovered document that defense wants to use as an exhibit,
Oh, just discovered?
which I would like to say would be the only time we've had this issue come up in this case, but unfortunately, it's not been the case thus far. We had some accusations or aspersions made as to why it hadn't been produced during the course of discovery in the case. And we have objections being lodged by the plaintiff as to the use of this at the last minute. And I guess since the defense is offering it at this point in time, let me throw it to the plaintiff side of this as to the objection to use of this for substantive or impeachment or any other purpose in this trial.
Yeah, Your Honor, we've never seen this document before, as I explained to you. Helios Global came up in the middle of discovery, as I didn't think it did, but Mr. Axelrod was kind enough to correct me. There were questions about Helios Global and one of the signatories, well, it's unsigned by Helios, but the person who's supposed to sign it from Helios, Ian Conway, is listed on the document, was talked about at the deposition. CNN chose not to send a subpoena to Helios Global for any documents. They made that discovery decision in the midst of discovery in the case. We did not have this document or would have been produced. And that does not mean Mr. Young violated his discovery obligations. If he signed this and returned it to Helios and did not keep a copy of it, this was in December of 2021, he was not in his care, custody, and control to produce it. So again, I've never seen it, so I haven't talked to him about it or what it is and why it exists. But the defense chose not to pursue it, and now they found out about it yesterday. Instead of doing what we did when we found out about newly discovered evidence, which was bringing it to your attention and asking about it and providing it to us as notice, they used it as a surprise document. They tried to forge
This is
dramatic
not good for
effects,
the
which is
defense.
wholly improper because we're not supposed to have trial by ambush in this state. And had this been properly, had I received this document, Judge, I'll tell you what I would have done. I would have handed it over to the other side. I probably would have went to you about it and then tried to figure out how I could do it. And I've demonstrated that I've done that time and time again. This is wholly inappropriate, and CNN should not be permitted to use this document. They should have provided it to us first, given us an opportunity to look at it, address it, talk to you about it. And the idea that they could never produce it to us, not give it to us, but hold it back and then try to use it as an impeachment exhibit when, by the way, it's not even proper impeachment because he answered the question yes. So there's no impeachment to be made. It's inappropriate. It's trial by ambush. It's being done inappropriately because they're desperate for something out of this case. And Your Honor, I just ask that you not let them use this document.
Your Honor, this is.
I've said to you all a number of times, let's not personal attacks or insults or laugh during other individuals' arguments in the case. So, Mr. Axelrod, go ahead.
Your Honor, this is a completely different situation. The plaintiff's entire case, sitting right there, is that after the CNN publications, he couldn't get any work. If you look at his complaint, Second Amendment complaint, paragraph 103, no one in Young's community will touch him. The CNN has turned him into an international pariah. Mr. Young knew when he filed this lawsuit that he had entered into a new consulting agreement with a government contractor 1 month after CNN's publication. This entire lawsuit was a fraud on this court. It was a fraud on CNN. This man knew it. I don't know what they know. But when this came up in discovery, CNN's counsel asked Mr. Young about the Helios connection, and he completely lied in his deposition. Over and over again, he made up some incredible ruse that Helios just had his security clearance because it was a company that held security clearances. It makes no sense. He knew at that time that he had a consulting agreement with Helios Global, and he didn't disclose it. It was not a right lie. This document should have been produced. I can go through the discovery requests that were sent that called for the production of this document. You can see that it's a DocuSign. You can see that it has his signature. You can see that it has his address.
That may all be true. But you found out yesterday, and you didn't provide it to court or opposing counsel. You used it as a surprise. And you can't use it for impeachment because in this, when you directly asked him, he said yes.
Same address for emails for their bank account. I have no doubt that there are other emails that he has or has destroyed. Mr. Young perpetrated a fraud on this court by lying in a lawsuit where he claimed his reputation in his business was destroyed by CNN when he knew fundamentally that was a false allegation. And the idea for Mr. Friedman that it's somehow CNN's fault that they didn't get a document that this is from December, and the record has already established that in December he was meeting with lawyers. If he had a duty to provide, I'm sorry I'm getting upset, but this case, Mr. Friedman's been talking to the press for years about what a terrible company CNN is. And I'm sorry I'm exercised by it. But the fact is, this lawsuit was a fraud from day one. Mr. Young should have provided this back in 2022. He didn't, and he's let this go on for years of money that's been incurred defending this lawsuit when there was a fundamental problem with it from the beginning, and they hid it. I won't say, hey, I don't know what he knows, but he certainly knew about it. And it was his obligation to keep this. It was his obligation to produce it. And if it had been produced to CNN in 2022, I don't know if we'd be here right now. Things would certainly look different. And the only reason we got this is we had to get it from Helios yesterday. It should have been produced over 2 years ago. And so the idea that, hey, first of all, we should have showed it to Mr. Friedman first, so his client could have come up with some other story about why it wasn't produced is ridiculous. And now he's benefiting from this, so I'm sure that there's some ruse that he's going to come up with next. The idea that we can't use this now because they failed their basic obligation as a litigant in a civil lawsuit. But somehow now we should be prevented from using the single most important document in this case. And I know that that's been thrown around by opposing counsel.
Again, maybe he should, maybe he shouldn't, but you didn't go down that avenue. Then when you found out yesterday, you didn't provide it to the court. You didn't provide it. Hey, we found this. And so tell the judge, we have a motion of dismiss here because we recently found out that the basis of this lawsuit is that is the correct way should have been the moment you got this document. You should have filed a notice with the court. Judge, we need to check something out here. We need to file a motion to dismiss because of something we believe the defense didn't produce. That is the correct way of doing it. And you didn't.
In this instance, it's true, because it decimates Mr. Young's claims. We heard him sit on the stand and testify. I got no work. Emotionally, I'm crippled because of what this has done to me. I don't know what the future holds because I have no work. But he knew it was all a lie. So I'll calm down for a second, and I'll say, Your Honor, that later on today, after I confer with counsel, we will be filing a motion about fraud on the court and gross discovery allegation abuses. But for now, the idea that I can't use this to impeach the fundamental concept of their case, which is that.
Well, now is a bit too late, in my opinion. Now is a bit too late. You should have done that before mentioning it in trial, as a surprise to the judge and the defense.
Mr. Young's a livelihood was destroyed by CNN. With the single most crucial document in this case, it would be a travesty of justice because they didn't produce it.
Let me get back to it. You asked him a question about Helios. And I think you asked him a question, did he sign a consulting agreement with them before you approached to say, let me hand you a copy of this? What was his answer to that question?
He said yes.
Okay.
The question was, I said, your assertion since the publications on November 11th is that no one will work with you. That's correct. Sir, is it true that in December of 2021, you signed a consulting agreement with a government contractor called Helios Global? Yes.
I like how this judge takes his time and thinks about his answers.
And I guess, Mr. Axelrod, to the extent that he answered your question, yes. How does the document impeach him?
The document does not impeach that specific question. You're correct, Your Honor. The document impeaches the entire theory of which Mr. Young has been promoting since April of 2022.
Yeah, but you still didn't tell the court.
You don't want to use it for impeachment. You want to use it substantively.
I do want to use it substantively. That is correct.
Right. Mr. Freeman.
Yeah, Your Honor, I mean, Mr. Axelrod made a lot of very heated accusations, none of which seem to hold water.
Everybody's made a lot of heated accusations during the course of this case. So
That's true, Judge.
but anyway, on this latest example, the ones that you want to respond to, go ahead.
That's right. The question I'm looking at in the deposition from Mr. Young is, have you done work for Helium Global? Answer, no, I hadn't. I never done any work for them per se, meaning I've never been paid by them. Ian is the owner of the company, Ian Conley. He's on an email and copy. A mutual friend of mine from a long time ago introduced Ian to me. I've never met him in person. We've had several discussions years ago about projects that he was involved in that he would like to be on to leverage my specific expertise to consult on. That's how this started. So Mr. Young never said, did not sign an agreement with Helios Global. In fact, I think in another place in his deposition, he says that he has a security clearance through them. For all I know, this document is what's necessary to maintain a security clearance, and Mr. Young's testimony will be that he did no work and was paid no work by Helium Global. I don't know, Judge, because I didn't have it. And Mr. Axelrod chose to try to use it by ambush instead of following the rules of discovery established to ensure due process. And what he's done is taken a document, he's hid it from me, he's created an entire cross-examination. He's got a folder ready to go on how to try to blow up Mr. Young on the stand by ambush, which is completely contrary to due process. Mr. Young has a right to counsel. He has a right to confer with his counsel about documents that are produced in the case, and allowing CNN to use this document now that they chose to hide from us after they got it yesterday. They could have produced it to us and filed this motion for fraud on the court, which I don't even understand how it's fraud on the court, Judge, because I don't know what the rest of Mr. Young's testimony is going to be. But, they could have filed that motion. They could have produced this document and filed that motion. They chose not to do that. It's obvious in order to try to create a trial by ambush. And it violates Mr. Young's due process rights to be put on the stand and be questioned about a document that was never turned over to his lawyers. That's my argument, Judge. CNN should not be permitted to use it.
I agree with the plaintiff.
I ask one other question, Mr. Axelrod. I mean, obviously, decisions to do discovery, not to do discovery, how you do discovery, I mean, those are obviously within the ambit of an attorney's mental impressions, work product, decision-making, or what have you. without getting into the context of that, and I'm certainly not asking you or on behalf of your team to disclose any of those mental impressions,
This is an
why
absolute
wasn't this
crap show.
document or obtaining things from Helios, because it did come up during the course of his October 2023 deposition, so I mean, a year and 3 months ago. Why was this, what'd you say, last night?
About 2 o'clock yesterday afternoon.
Yesterday afternoon? Why didn't this get obtained until
So
2 o'clock yesterday afternoon on the third day of trial?
yeah, you got the document while in court. Somebody on the defense got a hold of this document, which means that for a full 24 hours, they had this document and they chose to not disclose it to the court. Yeah, this is bad for the defense.
I'll give you 2 reasons. The first is,
And I know you're going to say because they didn't produce it.
that's the first one.
Separate apart from that, because the thing is, if something comes up in a deposition, obviously you have the right to test those things. We can do various and sundry investigative means to do it, but we had disclosure requirements. A deposition's October of 2023. This case wasn't set for trial until several months later. What we knew trial was this day, discovery cutoff was this day, exhibit list disclosure was this day. Why wasn't this obtained until 2 o'clock on the third day of trial?
Because Mr. Young lied in his deposition, and I'll show you exactly where. I'm on page 495, and counsel asked, I'm still struggling to understand, maybe it's just because I'm a layperson. Why do you want to know the current status of your security clearance when you reach out to these people rather than the Department of Defense? Mr. Young says, this is just industry norm. By this point, Your Honor, Mr. Young had renewed his security clearance with Helios both in November of 2021 and October of 2022. I also have those security clearances now. The process that Mr. Young went through, they were also not produced in this case. So he lied there, and he said, and then he says a number to call. You had pre-existing knowledge that if you wanted to know your security clearance, you should reach out to Helios Global, and he says, common knowledge. It was a flat-out lie. The reason why Mr. Young, shaking his head here after he's lied to this jury for the last 4 hours, is saying this, is because he had a consulting agreement with Helios Global, and he'd gone through the security clearance process twice with them already. If he had given a truthful answer to that, you better dang believe that CNN...
Still missing the mark here, Mr. Defense Attorney. Still missing the mark. You have had that document for a full 24 hours and chose to not disclose it to the court or the defense or the plaintiff's attorneys. That is the big mark here. Because if you had disclosed it, then you would have made the motion. Then they would have paused today to have a hearing about it. But you didn't. You chose to do it in cross-examination. That is, no matter how you believe Mr. Young lied or didn't lie, there still have to be due process rules. If you get knowledge, even during trial, Your Honor, we just got a hold of this document that, according to us, is telling us that Mr. Young is lying. And so, yeah, this is, in my opinion, part the defense didn't ask the right questions. Part is they didn't ask the correct questions, which allowed Mr. Young to avoid answering in full context. Then they waited for a full year, up until yesterday, when all of a sudden this document was produced to them through a subpoena. They chose to withhold it for a full 24 hours instead of immediately. If they had it 2 p.m. the day before, then the judge clearly asked at the end of court yesterday, is there anything else? And the defense said no. So if the plaintiffs, now I'm a day behind here, if the plaintiffs, they can actually use that against the defense. Judge, you asked them yesterday at the end of court, is there anything else? Is there something you want to talk about? They said no. And I don't know This is as fresh to me as it is to you guys.
And what is subpoenaed Helios Global.